Workers at the Tyson Foods Storm Lake, Iowa pork processing plant joined together and filed a class action lawsuit against Tyson, alleging that they worked without pay during the time they changed into protective gear and walked to their workstations. This case concerns Federal Rule of Civil Procedure 23B3, which concerns under what circumstances class actions can be certified, and in particular the requirement that there's commonality among plaintiffs to ensure not only that the plaintiff's interests are adequately represented throughout the litigation, but also that defendants can fairly defend themselves in this relatively streamlined procedure. And the issue in this case is whether a class of over 3,000 employees at a plant can be certified together when they all wore different equipment. They took different amounts of time to put that equipment on and take it off. And in fact, they were compensated in different amounts at different rates for different amounts of time. And that brings into question the limits on class certification and how common the class members have to be. Tyson argued that some of the class members were not injured and would not be entitled to any damages because they were in fact compensated for the time that they spent putting on and taking off their equipment. But the trial judge said that that didn't matter and passed over that issue and said that the broader issue of Tyson's compensation system was more important than the individual issues of liability and damages. Tyson's best argument is that class action defendants are entitled to an individualized defense of their claims. Due process requires that they get to determine whether they actually caused any harm and that they are only held liable for the harm that they actually caused. Here, the trial court completely glossed over that issue by imposing a trial by formula, which assumed that Tyson had hurt every single plaintiff and assumed that every single plaintiff had been harmed in the same exact way, when in fact that wasn't true. Trial by formula is where, instead of determining liability on an individual basis, the plaintiffs take a sample of a class, they determine liability as applied to that sample. They assume that all of the class members are alike in every relevant respect, and then they apply statistics about the sample to the class as a whole to impose liability. The Supreme Court said explicitly that trial by formula, while it certainly may make the plaintiff's job easier, it's unconstitutional. The best argument for the class members is that holding individualized trials would be impractical. It would defeat the purpose of the class action device. It would make the class action device impossible. And that the class action device is important. It exists so that class members can come together and bring claims that would not otherwise be brought individually. So in essence, the argument is that some considerations of due process have to be sacrificed to considerations of the policy underlying class actions and efficiency and ease, essentially. They also have the argument that trial by formula is accurate enough to satisfy due process.